Hi, Shani and Tal.
Hi, Philippa.
How are you?
I'm doing fine. How are you?
Good, good.
Do you have PowerPoint or something that you want to show?
No. Just old school.
Nice to meet you,
So
Philippa.
I'll speak for about half an hour, you said, and then we'll have questions.
Yes, just about.
Great.
שלומך שני, הכל בסדר?
בסדר גמור.
How many people are you expecting?
Hopefully around 20.
Okay. Hello, Yuval. Good to see you. Well, see your name.
How are you?
Very well. You're not with us in London yet.
Not yet, not yet. Soon.
The weather looks too good for London.
That's true. How are you?
Good.
Excellent.
Hi, יובל.
Hey, Tal.
נשמע?
Good. You?
Perfect.
Perfect. You're also not in London.
Not so much.
I hear the cat.
Of course, there's no Zoom session without the cat.
Yeah.
I lock the door, he jumps
Its
through the
expertise
window.
in international law is remarkable now, the cat.
Absolutely. He is a protected person in this house. I cannot do anything to stop him.
Great.
Hi, Eva. Hi, Catherine. Hi, Mirna, John. Good to see you. Philippa, is it okay if we will wait 2 more minutes?
Of course, of course.
Perfect, thank you.
Philippa, are you back to teaching in person fully now?
We've been back since January. But actually we've just finished teaching and now it's marking season. Yeah.
Tough season, marking season.
Yeah. Never gets more fun. At least now the improvement is that because students are sitting remotely, we at least get typed papers and we don't have to decipher different forms of handwriting.
Yuval, Moshe told us that he won't be able to participate, right? I think he wrote an email.
I don't know.
I think he wrote an email, okay.
So Tal, whenever you're ready, maybe
Yeah, I think we'll begin.
maybe
Okay,
we can start.
brilliant. Okay. So, hello everyone. Hi Rachel, Lior, Nicole. Good to see you. So we have with us today Philippa Webb. Philippa is the co-director of the Center of International Governance and Dispute Resolution and the professor of public international law at King's College London. Professor Webb serves on the board of various bodies and institutions, including, but not only, the Clooney Foundation of Justice, and in the past also the board of the European Society of International Law. She has extensive experience in international courts and tribunals, including, but not only, serving as a special assistant and legal advisor to Dame Rosalind Higgins during her presidency at the International Court of Justice. And she has taught in various universities, Inter Alia Graduate Institute in Geneva, Leiden University, and the National University of Singapore. Today, we are delighted to host Philippa with us and to listen to her presentation on Infodemic, state practice and international standards in the age of misinformation. Thank you very much again, Philippa, and the floor is officially yours.
Thank you, Tal, and thank you for having me. And it's good to see some familiar faces here. So my topic today is based on a work in progress, which is a co-authored article with Professor Marko Milanovic, who I think is a friend of Hebrew University as well. And it will eventually be an article entitled Regulating False Speech Consistently with Freedom of Expression, an Analysis of Basic Principles. So I will be basing it on that, but it is very much a work in progress, and I'm sure I speak for Marko as well, very much welcome comments and suggestions that you may have. So I'm going to address three aspects of this topic today. I'm first going to look at state practice, patterns, and some concerning developments. Then I'm going to turn to basic standards in international human rights law that apply to false speech, and some of the challenges maybe in applying these standards to various phenomena, and then end with some recommendations that Marko and I hope to make, focusing on recommendations to states, but possibly also to digital platforms. So first, state practice. As we know, with the start of the Russian invasion of Ukraine 3 months ago, we've had the real war on the ground, and we have an information war unfolding in parallel. So there's a reality that's continually contested in social media, state media, and broadcast media. So we've had questions over whether Ukraine was committing genocide against Russian speakers in the Donbass. We've had questions about whether Russia was indiscriminately attacking Ukrainian cities. Also questions about whether humanitarian evacuation corridors were being deliberately shelled. There was conflicting information, both true and false, about issues like this, often accompanied by images, video, photos, where we're not really sure we can believe what we see. And of course, Russia and Ukraine are not the only states that are involved in a struggle over reality. Elections have proved to be particularly vulnerable to the infodemic of misinformation. Let's just look at the Philippines and the recent elections there. The Philippines was once described by a Facebook executive as patient zero in the global disinformation epidemic. And supporters of the Marcos family have made skillful use of Facebook, which I think 98% of Filipinos get their news from, to change the narrative about their family and the crimes against the Filipino people. So Facebook, TikTok, YouTube have been used to recast the Marcos era, the first Marcos era, as a time of strong economic growth, whereas the reality is that it was a violent and dictatorial period. A fact-checking collaboration by various civil society organizations looking at the election material of the most recent Marcos campaign found that 92% of the material was false or misleading. And Australia, my country, has an election later this month. And recently the government announced that it had interrupted an operation involving Russian officials aimed at promoting candidates favorable to Russia in that election. And in the UK, there's been a report on Russian involvement in the 2016 Brexit referendum, suggesting that Moscow-based information operations, especially through social media and state broadcasters, had a significant influence in the result in favor of Brexit. And in the US, we have elections coming up in November, midterm elections. And in anticipation, the Biden administration has created a disinformation governance board, not only, they say, for election security, but also for national security. And meanwhile, Elon Musk has made a deal to buy Twitter for $44 billion. And he has said one of his priorities would be removing spam bots from the platforms. But at the same time, commentators have warned that efforts to roll back Twitter's policies could lead to an increase in disinformation, extremist content, harassment, and hate speech, which the company has been trying to crack down on in recent years. And let's go now back to Russia again, because on the 4th of March, President Putin signed a law creating new offenses that punish discrediting the Russian armed forces, any calls for sanctions against Russia, and the dissemination of so-called false information about the armed forces. The ordinary form of this offense is punishable by 3 years in prison. An aggregated form of the offense, if it is done by groups or for profit, is punished by 5 to 10 years in prison. And the strictest form, which applies if the dissemination causes grave consequences, which are not defined in the legislation, is punishable by 10 to 15 years in prison. It is not surprising that this law and the general atmosphere in Russia has led to the exodus of independent media, both international and local. So that's what we see in terms of concerning developments in state practice, and no jurisdiction, no state is excluded from the impact of disinformation. But I just want to step back for a moment and talk about terminology, because there's various terms floating around, including the colloquial term fake news, to describe some of what I have mentioned. So in the article, Marco and I choose to use the term misinformation, which we then qualify throughout the article with the relevant intent. And we just mean misinformation as false speech. And then we would describe when it has been intentional or reckless, or the innocent sharing and dissemination of information. But of course, I've also been using the term disinformation, which is usually used to imply that there was an intention to deceive. And you may have also heard of the term malinformation, which means there's an intention to cause harm. But I will try to stick to using misinformation from now on. And also in the article, we distinguish between two scenarios of the dissemination of misinformation. First of all, by the state itself, through its organs or agents, disseminating misinformation. And the second, where the state is attempting to protect its population from the harmful effects of misinformation disseminated by others, by other states, by companies, by organized groups, or by individuals. And it does so by restricting freedom of expression. And that second scenario is the one that we focus on in the article when we talk about the application of basic principles of international human rights law. But I just don't want to lose sight of the importance of state-propagated misinformation, because that can actually be far more harmful and widespread than misinformation by non-state actors. I would also say that the dissemination of misinformation by state agents is not just about the spread of false speech, but it can pollute the information space so much that it denies an individual's ability to seek and receive information, which is an aspect of freedom of expression. So there are some places where the state has such a tight control over the information environment that it is almost impossible for a citizen to acquire accurate information. And, consider again Russia, which has shut down virtually all independent outlets. And in the words of Dmitry Muratov, the editor of Novaya Gazeta and the 2021 Nobel Peace Prize laureate, he said, everything that's not propaganda in Russia is being eliminated. So let's go to the basic principles. What has international human rights law set up in terms of a framework for dealing with restrictions on freedom of expression? And the first question is, can restrictions on false speech, on misinformation, be justified in principle? And the answer is yes. Freedom of expression is not an absolute right. Its restrictions are built into international human rights law, but it is a three-part test for justifying those restrictions. And this will be very familiar to some of you. Any restriction on expression must be provided by law, it must pursue a legitimate aim, and it must be necessary and proportionate to achieve that aim. So the UN Human Rights Council has affirmed, specifically in the context of misinformation, that responses to the spread of misinformation must be grounded in international human rights law, including the principles of lawfulness, legitimacy, necessity, and proportionality. And they underlined the importance of free, independent, plural, and diverse media, and providing and promoting access to independent, fact-based and science-based information. So that's the UN Human Rights Council applying those well-established principles to the phenomenon that we've been discussing. And necessity and proportionality are always measured against the legitimate aim that the state is supposed to be pursuing. And then you can break down necessity and proportionality into further questions. So we can say three further questions. First, suitability. Is the restriction on speech a suitable measure for achieving that legitimate aim? Second, least restrictive means. Could the state have achieved the same result through other less restrictive means, which don't involve, for instance, criminal liability or a total shutdown of a website or a other form of broadcast media? And third, proportionality. Did the state strike a fair balance between the interests of the individual and those of the wider society that it seeks to protect? And a key factor will be the nature of the harm that the state is seeking to address, and also the proportionality of the penalty being imposed on the speaker. And I'll give you some examples later on of legislation that would not meet these conditions. So back to the point of principle, yes, you can regulate false speech as a state, as long as it can satisfy these conditions. But we're not regulating false speech solely on the account of it being false, but because of the social harms that it causes. And we have to bear in mind that there is a danger in having the state, even if it's a democratic state, as the arbiter of truth on matters of public interest. People talk about the marketplace of ideas, that this will eventually allow the truth to come out. But we know, and I think it's increasingly obvious, that the marketplace of ideas can easily be distorted by power, by money, $44 billion worth maybe, and also just by the limits and tendencies of human psychology. We are more susceptible to misinformation. It is more exciting, it is more memorable to follow scandalous information, disruptive information, unexpected and shocking information. That sticks in our minds and is much more susceptible to sharing than maybe the more boring fact-based, science-based information. And Article 19.3 of the International Covenant on Civil and Political Rights provides that freedom of expression may be limited for where it is necessary for the respect of the rights or reputations of others, the protection of national security or public order, or public health or morals. So we already have built into this key treaty that 173 states are party to, these legitimate aims for restricting speech. But there has to be the laws that pass that seek to justify themselves on conditions like Article 19.3 have to point to the harm, or at least it must be discernible. Because as I've said, the falsity itself is not sufficient as a relevant harm. And I want to give you an example, which is the Malaysian Anti-Fake News Act of 2018, which has since been repealed. Section 4.1 of that act made it an offence to maliciously create or disseminate any fake news or publication containing fake news. And that would lead to 6 years in prison. There was no mention of a legitimate aim, a harm that was being addressed. It was the dissemination of any false information on any subject, regardless of any harm, that would lead to a criminal offence with a substantial prison term. And the UN Special Rapporteur on Freedom of Expression found this to be in breach of the conditions in the ICCPR, in particular because it was too vague with disproportionate penalties. So next point of principle, any restriction on protected expression needs to be necessary and proportionate to the harm that it is seeking to guard against. So another argument that is used in these debates about misinformation is that it is through public debate and through the role of the press as a watchdog of the government, this is the term constantly used by the European Court of Human Rights, the press as the watchdog, that the truth should be defended. But some people take that further and say, we don't need restrictions on freedom of expression for misinformation because more speech can cure the problem. So someone says something false about the war in Ukraine, well, you just have to counter that with the truth about what's happening in the war in Ukraine. But once again, this doesn't really reflect how our information environment works. The target of the misinformation cannot necessarily easily and rapidly reach the same audience as the original communicator of the misinformation. Any correction that is made may be too late to address the damage that has already been spread like wildfire through social media. And if we just take the pandemic, misinformation may have already caused direct harm to human health before the correction can be made. So hundreds of people were reported dead in Iran after ingesting methanol, which misinformation online had caused them to believe would cure them of COVID. So more speech is not necessarily sufficient. Next principle is the greater the degree of the speaker's culpability, the lower the level of protection that speech enjoys. So if you have a speaker who knowingly and intentionally engages in false speech, knowing or intending to cause harm through that speech, they will enjoy less protection for that speech than a speaker who was merely negligent in failing to verify the accuracy of the information that they shared, or was negligent as to the consequences of their speech. Generally, Marco and I argue culpability and causality standards should be matched to the severity of the sanction imposed by the body. So if you're going to have a government or a regulatory body that is going to impose very severe fines or even to shut down a media outlet temporarily or permanently, then that will require a very high degree of culpability and causality on the part of the speaker. The Venice Commission has pointed out that excessively high fines pose a threat with almost as much chilling effect as imprisonment and can even be more insidious. But of course, it's not just the government that is regulating speech. Especially for online speech, we have the powerful digital platforms. And they are on a sort of evolving basis deciding how they are going to regulate speech. And I'm going to come to some of that practice in a moment. But just on this question, who and how decides on whether information is true or false? Well, we have the courts, of course, but we know the courts are in most countries, if not every country, fairly traditional, fairly slow moving. You may get an interim injunction, you may get provisional measures, but to ultimately litigate a case about misinformation is not going to be fast enough to deal with the consequences that may arise from that misinformation. So they are a mechanism, an important mechanism, but not a very responsive one. We also have independent regulators in many states, and some of those are co-regulating with the state itself, or they may be completely independent. We also have the executive branch playing an important role in some states, and that in itself can also be dangerous. And I want to give you another example here, which is Singapore's Protection from Online Falsehoods and Manipulation Act 2019, which is abbreviated as POFMA. Under POFMA, individual speakers and internet intermediaries can be required to label content as false or to remove it altogether. But who decides that? Any government minister in the Singaporean government under the legislation. So it is not limited to the Ministry of Justice. It is not limited to a Minister of Communications. It is any government minister. You could have the Minister of Transport deciding that something is false online and requiring its removal under this act. All it requires is there is a false statement of fact communicated in Singapore, which is in the minister's view, not in the public interest. So this law was passed in 2019. And when you look at the directions that have been issued under this law, they have almost exclusively been against persons criticizing the government for its policies, and never against persons who may make false statements in support of this government. But of course, as I've already flagged, the state is not the only gatekeeper, and any regulation on speech on the basis of misinformation has to take into account Facebook, Twitter, and the decisions that these platforms are making. And Marco and I recommend that they should be complying with the principle of legality and transparently defining what type of misinformation is subject to removal or moderation. So now we come to the proportionality of penalties, which is part of the assessment of necessity and proportionality. Regulatory measures that are just a censure of a speaker or correcting the speech that has been made are comparatively easy to justify under international human rights law because they're not a severe penalty. But when you get into fines that may affect the operation of a media outlet, and there have certainly been cases, including recently in Ecuador, where a newspaper was accused of sharing or publishing false speech and was subject to a $30 million fine, which is completely unsustainable for a media outlet in that country. That would require substantial justification. And even on its face, it's prima facie disproportionate. So then you come to even more severe measures, the revocation of broadcast licenses or even shutdowns, those will require deliberate, repeated, and systematic spreading of misinformation, causing serious harms. So a very high bar. We say, Marco and I, that criminal law can only be used in very narrow circumstances with regard to misinformation. We say when it incites to violence, when it causes other serious harms to human life and health, where it directly and immediately harms the integrity of elections. And then there's other examples such as perjury during a judicial process, fraud in relation to property rights, or speech that incites hatred or discrimination against a specific protected group. And all of those would be with a high culpability standard. So I come now to our recommendations. And as I said, I very much welcome your comments on them. Let me just run through them. So we say state actors must refrain from disseminating or amplifying harmful misinformation, and authorities should make all reasonable preventive efforts to ensure that their subordinates are not engaging in such activities. We say states must not adopt general prohibitions on the dissemination of misinformation. They can only restrict it if it produces a concrete harm that is linked to a legitimate basis for limiting speech under international human rights law, Article 19.3, and the law must be narrowly tailored to protect against such harm. Misinformation laws must pursue solely aims regarded as legitimate under international human rights law, such as protecting public health. State authorities shouldn't be acting with ulterior purposes, such as suppressing criticism and dissent of the government or other organs. And in particular, in exercising their jurisdiction, domestic courts should ensure that other public authorities have not acted with those ulterior purposes. Misinformation laws must not grant excessive discretion to state authorities. This is the POFMA example. In exercising any discretion granted to them by law, state authorities must act with care so as to minimize the chilling effect of misinformation laws and avoid amplifying harmful effects. And any exercise of such powers should be subject to an independent and impartial judicial review. Then coming beyond the state to digital platforms and media companies, they should recognize their responsibility to respect human rights in their sphere of operations, including but not limited to freedom of expression. They should apply international human rights standards to guide their decision-making. They should also explicitly commit themselves to the UN Guiding Principles on business and human rights. What does this mean in practice? This means they should avoid infringing on the human rights of others and address the adverse human rights impacts that may be flowing from the use of their platform. Now, we all know that international human rights law was developed to regulate the relationship between individuals and states. But we say, Marco and I, that they should be applied with any necessary and appropriate adjustments by private companies to guide their own decision-making. And that's not just the substance of it, but also the procedural aspects, acting with due process, allowing review, allowing appeal. And I would just like to, I started on a very negative note with the waves of misinformation that we're seeing, but I'll end on a more hopeful note, which is that an increasing number of these digital platforms have accepted international human rights as part of their internal regulatory frameworks. And this gives some hope for some harmonization in this area and maybe some best practices emerging from public-private interaction. Thank you.
Very much, Philippa. Very insightful. We will now open the floor for discussion. With your permission, I will be happy to kick off the discussion with a few questions. Starting from the last point you mentioned, so it is wonderful that companies adopt human rights standards, and we can think of the example of the oversight board of Facebook, which try to use it in its rulings or quasi-rulings as well. but how much do you think that it will be done in practice? At the end of the day, many oil companies and other companies are declaring of adopting human rights standards. Apologies. In Israel, we have the recent example of NSO, which even published a transparency report and etc. And they have an advisor on human rights. They have a board which deals with this question, etc., etc. But in practice, it doesn't really help. More specifically to the topic, you began by categorizing or differentiating between mis, dis, and malinformation. I was curious, do you also differentiate between the subject of the discussion, namely a truth, a partial truth, inaccuracy, a lie, a blunt lie? There are layers and degrees also in this respect as well. And finally, you mentioned the issue of prevention. So I'm curious to know, it seems like you are following very strictly the lines of the ICCPR, the purposes which are included there, or the need to avoid the incitement under Article 20 and etc. etc. But what about due diligence? Because you said prevention, but states have a duty of due diligence to prevent violations of international law from occurring from their territory. But it's not only prevention; it's also investigation and prosecution and punishment. A state can fail in preventing, but meet its due diligence obligation by investigating, prosecuting, and punishing, right? But in this specific context, disability makes the rule not useful, apologies. Because if we have not prevented the misinformation, then even if you will investigate and punish and etc., the damage was done. So in a way, due diligence is not helpful in this regard. So I'm curious to know, as you are following the lines of human rights and as due diligence is a big issue and part of the analysis and basically a backdoor when the direct obligation does not fit the analysis, I'm curious, what do you think of that rule's place in your discussion? Thank you.
Thank you. Lots of food for thought there. So your first sort of cluster of questions, do these, oversight boards, human rights advisors actually make a difference, these oil companies adopting human rights standards? So I think they do. And I can give the very concrete example of resource extractive industries being sued in the UK. So we've had a series of cases against Vedanta, Shell, also Unilever, who are either headquartered in the UK or have some other jurisdictional link to the UK. Shell is obviously in the Netherlands. And it's not about anything they're doing in this jurisdiction, but because of allegations of human rights abuses by their subsidiaries. And that includes sexual violence in Kenya on tea plantations. It includes abuses against Indigenous peoples. It also includes environmental damage. And those cases have gone all the way to, at least the Vedanta case, to the Supreme Court in the UK. And the Supreme Court looked at the fact that these companies have beautifully drafted human rights standards that they put all over their websites, adopting the UN guiding principles and, stating their values, the exact kind of website. And they also have human rights advisors, and they have local engagement officers and all of that. Probably thinking that it was good PR, at least some of these companies. And what the Supreme Court said was actually, no, you have undertaken now to comply with these standards. You have published them. You have taken the reputational advantage from them, and you now are held accountable to them. So they have allowed those cases to proceed. And so it wasn't just having a fancy website with nice colors. it actually is going to lead on a domestic level, on a sort of a transnational tort litigation level, to accountability for those companies. Now, on the one hand, so I think that's very positive, and I think that's going to lead to compensation, at least in those cases. Bigger picture, I wonder if it's going to make these companies more cautious about what they put in their policies, which could be a kind of negative impact. I don't think we've seen that yet, because there's such a movement towards ESG and the importance of that and ethical investment. So they've got these sort of different motivations for including those human rights standards. But if they do include those human rights standards under English law, they will be held accountable. The oversight board at Facebook, I mean, there's been a lot written about the pros and cons of it. From the decisions I've read of it, I find it to be pretty solid. My main concern about the oversight board is that it doesn't have oversight over everything. So there's certain conduct on the platform that the oversight board can't touch. But are we aiming for a perfect system, or are we aiming for just an improvement on the status quo? And I think if we're realistic, these kinds of practices are improvements on the status quo. Interestingly, on NSO, maybe what's going to have more of an impact is the litigation, again, that's being brought against them, at least I know in the United States. And there's UK litigation that's not against NSO itself, but against NSO's state clients for cyber surveillance and associated personal injuries and property damage that's filtering through the English courts at the moment. So all of this, I think, is going to be paid attention to. So I'm more hopeful maybe than your question suggests. Do we differentiate by subject matter, lie, white lie, blunt lie? Not as such using those terms, but what we do is in terms of culpability. So we talk about innocent dissemination. You know, the person who sees a Facebook post talking about, you know, cures for COVID using disinfectant and shares it, and then someone uses disinfectant and ends up in hospital. We say, you know, that is obviously a serious harm, but the culpability level wasn't very high because they genuinely believed that that was helpful information to share. Whereas if it was someone who knew that this was a false cure and that it would harm people and then disseminated it, that would be a higher level of culpability. So that's how we address it throughout the draft article. But it's an interesting thought that we might also be able to tie that to some kind of description of the harm being done. I mean, one of the things that Marco says when he speaks about this is we're not talking about the good lies, we're talking about the bad lies, but we then do break that down into the mental state. And you make a very good point about due diligence and how prevention actually has a lot of work to do here, potentially, because once the fake news is out there and circulating, and then the bots and trolls are amplifying it, you know, potentially millions of times, you can't put that back in the bottle. So prevention is really important. I think that's still an area of international human rights law that needs more thought and development. My just initial response to your question is, I think by being much more transparent about the standards that are being applied and holding either private sector or state authorities accountable for misinformation, hopefully that will have a deterrent effect. And so the deterrents will contribute to prevention. But that's only going to be possible if there is enough accountability to actually deter entities and people that benefit from the spread of false information. And I'm not idealistic to think that Russian trolls are going to be concerned about the fact that if they ever travel to the UK, they could possibly face a trial that would last 3 years. That's not going to be part of their calculus. But maybe for some others based in the UK, it could be. But certainly an area for us to think more about. And I would just say, not on due diligence, but on, because I think you mentioned due process as well. For that purpose, Marco and I look into obviously the right to a fair trial and the standards there. When there's so much that already exists in terms of international standards that we don't have to reinvent the wheel every time. And certainly for making sure that there's an independent and impartial body, that there's opportunities for review and appeal, that there's opportunities to make a defense, all of that, we already have human rights standards to guide us.
Thank you very much, Philippa. I did my best, but nothing passes by you. You didn't miss anything. But I was just the opening act. So I'm glad to deliver, to pass the microphone now to Yuval, please, for the next question. Thank you very much.
Tough act to follow, Tal. I can recommend you a good book on due process, Philippa.
I think it might be on the bookshelf behind me.
Yeah, but I mean, I wanted to perhaps proceed from where Tal, some of the points Tal dealt with, and maybe take them a bit further. So I think the issue of categories is interesting, because at least in the social science literature, there are different typologies about how distant is the expression from a truth or a perceived truth, and there is this distinction between lies and bullshit, disinformation, misinformation, and I think it's picking up momentum now with the Ukraine war, where there is a sense that some actors are completely, some are playing with the truth, but some are completely not wedded to the truth in any real way. And I think there is also there is also treatment in some regulatory frameworks to some deliberate productions of misinformation, such as deepfakes, which are treated somewhat differently than other expressions of misinformation. And maybe also conspiracy theories are also being elevated to a different level of regulation. So I think you would have sooner or later to develop a more precise categories of disinformation, of misinformation, partly because I think this is an area where regulation is going to be extremely difficult. And I will say a couple of words about this soon. And you also have to basically not only deal with states, you have to deal with companies, and not only with companies, you have to deal with engineers who are, basically developing algorithms that would have to identify. So basically, to tell an engineer, you have to basically identify cases of disinformation is going to be extremely hard, because it is extremely hard even for very well experienced lawyers to use the different categories. I think here you would need to identify some more specific technology, more specific definitions that have a technological representation in order to make this worthwhile. So that was one aspect about the categories. The second aspect where I think what you're doing is very important. I think you may be a little bit too optimistic about what human rights law could actually bring to the table in terms of substantive norms. I'm fully on board with you about transparency and about developing a process and having individuals being in a position to complain, what have you. But I think in terms of if you look at the substance, for instance, the Human Rights Committee had itself quite a difficult experience with the so-called truth laws, with the idea. So this is not about technology, but it's really about the substance. I mean, to what extent can states regulate speech by reason of its veracity or lack of veracity? And there has been some pushback after Forisson, we're dealing with Holocaust denial, and General Comment 34 seems to be much less tolerant of truth laws. And in fact, the pendulum might have swung in the direction of criticizing states who are trying to control the truth, so to speak. I think also there's the freedom of expression rapporteur was critical of criminalizing fake news or disinformation. So I think it's fair to say that at this point in time, international human rights law doesn't have a very clear position on a requirement, a positive obligation to actually care about disinformation. And this is very different from hate speech, where you do have the Article 20 ICCPR obligation and also the Article 20. So I think you're on more solid footing when you're talking about, and I think you mentioned this, when you have disinformation that also produces harm in the real world. I think there you have something to work with. But when one is dealing with disinformation, when the harm is somewhat abstract, such as undermining faith in government, or undermining faith in science, or in climate change, or what have you, I think it's going to be quite difficult to make a legal case that this is a violation of a treaty norm. And there would also be a question of how far do we want to push this agenda, giving, and with this, well, maybe I have one small thing with this I wanted to conclude and maybe just make another quick observation. So you have these three problems. First, the companies are going to err on the side of caution. So a DSA plus liability process is probably going to remove a lot of contents from the online sphere because they will be very concerned about fines, etc. Second, there are huge epistemic issues about what is truth, etc. And is there something objective that is truth, and also what is harm. So I think it's going to be a very difficult thing to pull through. That doesn't mean I don't want to discourage you and Marco in any way. It's very important that you're diving in, but this is, I think, more. I see it really like, you know, we are now taking the preliminary steps in dealing with this. Obviously, governments are moving much quicker than our conceptual thinking has so far developed on this. And finally, I just wanted to comment on the issue of proportionality. I think that's, of course, a very good point. I think there will be, in practice, also a lot of proportionality issues relating not only to the sanction, but also to the response by vis-a-vis the speech itself. So I think there is a big difference between labeling and between removing and between slowing or between sanctioning. So actually, I think criminal law is probably the least likely avenue in which these things are going to be pursued, partly because, you know, of anonymity, partly because of jurisdictional issues. So I think maybe there could be more focus about applying the proportionality analysis to the reaction, not to the perpetrator, but actually to the content itself. I'll stop here. Thank you.
Thank you so much. I am not going to be able to respond to all of those points, but I've taken note of them to discuss with Marco, certainly. But there's a couple of things I would like to respond to. And I wonder, as you were speaking, I was trying to pull up your recent EGIL article with Daphna Dror-Sploliansky on the end of the offline world as we know it, from human rights to digital human rights, which I've actually been engaging with for a talk I have to do tomorrow on fair trial rather than freedom of expression. But I wonder if, you know, there's an overlap here on that. I just wanted to come back on the idea of categories. So yes, I agree. The more specific we can be, the more we can disaggregate the different types of misinformation and look at them in terms of levels of culpability, levels of causation. I think the more useful it's going to be for both assessing whether there has been compliance or not, but also for advising states on their, legislation and other practices. But when you made the point, and I think in connection to deepfakes, that the definitions of categories should also be engaging with the technological elements of how the misinformation was produced. I just wanted to come back to you on that. Is that because those types of speech, which include, of course, videos and images, can only really be diagnosed through an expert process? So is it only the diagnosis and removal elements or correction elements that you think put those in a special category, or is there something else about their regulation?
Yeah, I think it's both. I mean, in terms of diagnosis, I mean, this is something a technician can diagnose. A technician doesn't need, I mean, someone who has, I mean, unless it's extremely well done, but I mean, people with strong technological capacity can identify whether a film has been doctored with, etc. And maybe this is even something that an algorithm would be able to detect. So in terms of detection, it's a different story from when you write a line in an article, and you would need to assemble a group of experts to discuss. But I think also in terms of its, I mean, if the protected value here is about protecting individuals from manipulation and from being misled, I think images have a very strong ability to mislead. They may have a stronger ability to mislead than verbal contents. So maybe also in terms of the potential harm, I mean, this is, of course, it has to be addressed on I mean, if it's a cat movie, it's one thing. I mean, but if it's something that has to do with political expression or with the commission of a war crime, I mean, it's a very different thing. So the context is important, but I would say all things being equal, I mean, it has the potential of it has ab initio the potential of creating more significant harm than a verbal form of misinterpretation, of misinformation.
Yeah. I mean, I have to think about this and discuss with Marco, but I still think our approach of defining the speech and the type of response that would be proportionate or even required to be made in response to it through levels of culpability, causation, and the distance there, and then the type of harm that it may cause, may be able to accommodate these more challenging diagnostic types of speech. But I fully agree with everything you're saying. I'm just thinking about the impact for our framework and whether it probably still will work. But as I said, it's something I'm going to think about. And I fully agree with your point about solid ground when we talk about disinformation in the real world, compared with undermining faith in science, in the reality of climate change, in government, and certainly the integrity of elections, I think, is just not protected in any jurisdiction and requires the due diligence that Tal spoke about as well. Probably our recommendations need to focus on that even more so. And finally, I just wanted to pick up on your point about denial laws, because I agree with you. We've had a pendulum swinging back and forth, and maybe just for the benefit of those on this call, to just give you what actually general comment number 34 says on this. So it says laws that penalize the expression of opinions about historical facts are incompatible with the obligations that the covenant imposes on states parties in relation to freedom of opinion and expression. The covenant does not permit general prohibition of expressions of an erroneous opinion or an incorrect interpretation of past events. So its position was safeguarding the truth about past events, and that that cannot in and of itself justify restrictions on freedom of expression unless, as in Forisson, denialism was a coded form of hate speech. but I think you might have been referring to Perenchek from the European Court of Human Rights, where the court found that it was not justified to restrict the speech of an individual who was denying the Armenian genocide. He was actually a politician denying the Armenian genocide, because it was not established that in doing so that he was actually calling for hatred, violence, or intolerance. So, it's an area, I think, of evolution and divergence. And I also think that recent events, not just in Russia and Ukraine, but in the rise of anti-Semitism that we see in various jurisdictions, requires this to be really carefully considered.
Thank you very much, Philippa.
The co-author of the EGIL article. Yeah.
So Daphna, please, you have the follow-up permission.
Hi, thank you so much for this great lecture. So my question is about the enforcement element and the incentive for enforcement, because I mean, when we think about close examples in international law of applying international human rights law on companies, which you have mentioned, we look, for example, on the Ruggie principles, but there was an incentive, a clear incentive for states to enforce it on companies, to protect individuals, to protect the rights of employees, environment rights, etc. But here we are in the digital arena. We are I think in a situation where, on the one hand, we have the companies that has financial incentive to promote this information. As you mentioned, it's something that humans are more curious about. And on the other hand, we have the governments that sometimes they are the ones to promote it for their interest, and even companies that had to kind of exile governors, such as the case in Brazil and other cases. So I'm curious to hear your opinion about this element. The fact that we are in a very different situation of incentives than it was in the case when the Ruggie principles were created, for example, to apply international human rights law on private companies. Thanks.
Thank you very much for the question. And as with anything in international law, enforcement is always the trickiest bit, because we're usually dealing with trans-border or multi-jurisdictional phenomena, and our states are very inward-looking, and then you have the UN that doesn't have the enforcement powers that would deal with these international, transnational elements. And it's no different in that way. But I don't know if I see the incentives issue as so clear-cut. Yes, companies have a financial incentive to promote misinformation on the one hand, because it increases the number of clicks and it increases the advertising, and it gives rise to more users because they want to see the exciting material that everyone is speaking about. But at the same time, it is extremely damaging to the reputation of those companies when it is revealed, for example, that Facebook was sharing and permitting communications that led to the persecution and genocide of the Rohingya people in Myanmar, that this was all being disseminated and even coordinated through that platform. And on the one hand, that's reputationally really damaging to Facebook, and they then did belatedly take measures to remove that content and prevent that content. But they're also going to be facing financial consequences potentially, because they're being sued, I think in the UK and the US, for the harm caused by the permitting of that material when they knew or should have known it could cause such serious harm. And I think they're facing potentially millions and millions in liability. Now, those court decisions haven't played their way out, but that's still a very expensive and reputationally damaging consequence for Facebook from that. And also statistically, the growth in the users of Facebook has dramatically dropped, and that's for a number of different reasons, but this clearly doesn't help. And also the incentives for governments. Yes, they have the incentive to promote misinformation that silences the opposition and that puts them in the best light. But just the very nature of social media means that they can't control that it's always going to be a pro-government stance, unless they've essentially, as in some states, created their own social media and don't allow any other platforms. But that's only a handful of states. In most places, you are going to be able to have free access to other uncontrolled, at least by the government, social media. And there's certainly no guarantee that it's all going to be pro-government. In fact, it's guaranteed that there will also be the use of these digital platforms by the opposition, by civil society, and also just by troublemakers who want to generally disrupt what may be going on. And I would like to think, at least for democratic governments, that despite the small advantage that you could perceive from allowing misinformation about your opposition, that ultimately you would want to protect the integrity of elections, because your own legitimacy and credibility will ultimately rest on that. So I don't see the advantage. I don't think we've tipped the balance to the side of letting misinformation run wild in order to take the advantage versus having some level of fact-based, science-based, and election integrity as well. So that was my comment on the incentives. On the enforcement, as I said at the beginning, I think it is very challenging, but we're seeing some creative transnational tort litigation at least. And I think, back to Tal's observations at the beginning, I think we might be seeing the rise of a new type of accountability, like the Facebook Oversight Board, like the NSO mechanisms and human rights advisors that have been put in place, which are these kind of internal mechanisms, internal justice systems. I mean, something that the international organizations have had for a long time, and now we see it in the private sector. Once again, imperfect, doesn't cover everything, may not be entirely impartial, but it's a mechanism that's starting to be developed.
Thank you very much, Philippa. Our next question will be by Elizabeth. Please, Elizabeth.
Thank you. Right, my question maybe comes from a slightly different angle than the questions before. Initially, you mentioned in the paper also the classical distinction between positive human rights obligation and negative human rights obligation. And then I have a feeling that during the paper, you mostly touch on those negative human rights obligation as in how far need the state refrain itself from mingling or restricting freedom of speech. But I would also be interested maybe in your thoughts on this more positive obligation, especially when it comes to international corporations like media, Twitter or whatever. In how far would the state maybe have an obligation to ensure that they also in some way respect freedom of expression? For example, I can imagine a very, very extensive sort of and maybe even arbitrary regime of those corporations that would delete, say, a big amount of content due to the suspicion that it might be false speech or whatever, and how far would maybe the state then have the positive human rights obligation to interfere there? this would be my first question. And the second question is a bit also maybe beyond the scope of the paper, but you talk a lot about like very like positive law forms of restriction. And I'm also interested in how far like more soft forms of restrictions, or even maybe not restrictions, could count as restricting human rights when they come from states or from corporations. What I had in mind is the whole like hot topic of like political correct speech and like shaming regimes and whatever, and how far such regimes would count as a restriction of free speech, and how far then maybe the sort of human rights obligations play in.
Thank you, Elizabeth. Just before that, in response to Daphne's question, I was trying to think of on the enforcement point, I was trying to think of an article that I had seen on this. It's actually by my former PhD student, which I want to commend to you. So it's an article by Rishi Gulati, and it's called Transnational Hybrid Adjudication, a case study of the Facebook Oversight Board. I'm trying to think, I think this is coming out in the Max Planck journal, and is shortly about to come out. But what he argues in that article is that the Facebook Oversight Board may be the beginning of a new form of enforcement, not to replace anything that already exists, but an additional form that may fill some gaps, which he labels transnational hybrid adjudication. And anyway, so I find his argument very interesting, and I think we may be seeing more of these such bodies, especially given the jurisdictional limitations of domestic courts. But back to Elizabeth's questions. Thank you. So positive obligations are much harder to enforce and litigate because they are obligations of means, including what the state reasonably could do in the circumstances. And that's going to involve the jurisdictional ability of states, their resources, their ability to influence, an international digital platform, for example. So Marco and I deliberately have not addressed them in any detail in this paper because there's much less to sort of point to and to say in terms of practice and recommendations at this stage. But given your example, I think if there's an extreme example that you gave, like the deletion of an entire website or communication platform, I assume in your example it would be done by a private actor, and then the state. I mean, I think it would depend on the circumstances. What was the harm that it was seeking to address? Why was it disproportionate? What were the less intrusive means? And had the body that deleted it actually undertaken to comply with such principles? So then the state may be able to respond through its regulatory body, through its administrative law. And this goes back to Yuval's point that given so much private influence in this area, especially on the corporate level, we're not really talking so much about criminal law, but we're talking about administrative regulatory action. So suspension of licenses, temporary blocking perhaps, but with conditions to fulfill to be reinstated. It would have to, I think, be a very extreme situation, such as inciting genocide, inciting aggression, and so on, to lead to, in my view, a total shutdown.
May I specify maybe a bit?
Yeah, sure.
What I had in mind was more probably perhaps the other way around. What I had in mind was the Twitter Trump case, where a US court recently held that like, because Twitter is a private company, they don't have to sort of comply with freedom of expression standards. And I would just be interested in whether you share that view, or whether you would say, no, the state sort of has to see to also private companies complying with these standards.
So you mean for the United States to intervene to require Twitter to
comply with freedom of expression standards? I mean, totally, it's a different, separate question as to whether, you know, deletion of Trump's Twitter account was then justified, blah, blah, blah. But like, just like the first step principle of like private corporations and or like social media platforms and their human rights obligations, not obligations, and how far the state should intervene there, because they have undeniably a huge influence on communication and on expressions everywhere and the spread of information.
Yeah, as you said, it's a bit of a different topic about the relationship between non-state actors and the state and their ability to regulate them. I think I would just say it's definitely not a given that the state would be able to regulate the private actor. You would have to look at, you know, the jurisdictional links, the nexus, and also I think in the case of freedom of expression, and this goes back, you know, to some of the earlier points being made, what that private actor has voluntarily undertaken to comply with. So there's one question of how much can the state, you know, legislate to affect or, you know, decree to affect the behavior of that private actor, but also we have private actors voluntarily saying, well, we're going to apply the standards as set out in the ICCPR. If they've done that, then I think there is greater capacity for them to be held to that, either by an international body, an internal body, or possibly the state, if they've got sufficient jurisdiction. But yeah, as you said, it's a whole other debate in international law about how you hold non-state actors, especially international non-state actors, accountable. And just briefly on your second question on soft law and political correctness and so on, I would just come back to the international standards and say, is this a legitimate aim? Because political correctness, you know, cancel culture, all of these things I think you were referencing is like a huge spectrum of behavior, and I think you would have to test it against Article 19.3 and Article 20 of the ICCPR. Is what's being cancelled or regulated a legitimate aim for protecting the rights and reputations of others, or perhaps for public order or public health? But I would be returning to first principles there.
Thank you very much, Philippa. If you're up to it, we have one last question.
Yes.
It's okay, perfect. So Lior, please.
Hi, thank you. My question is in regards to the dichotomy between state regulation and the media's regulation, since in Israel there's this practice that the cyber unit in the Attorney General's office goes to Facebook, for instance, and declare or ask Facebook to erase some of the posts since they are contradict the self-regulation that Facebook has taken onto itself. And in its judgment of the High Supreme Court in Israel, the court says that the act of approaching the media outlet is an administrative act, but the regulation goes reversely. I mean, the state approaches the media outlet and says there is a breach of your rules. And in that extent, we can see a new practice in regards to the connection between the state and the media outlet. And I think that in that regard, I would like to know what is your approach in regards to implementing the standards that you just raised, because this is a unique scenario. This is not the classic state regulation.
Can you just explain to me, Lior, why you said, I didn't understand when you said this was a reverse.
Since the regulation is Facebook's. The state
Oh, right.
Facebook and says
Okay.
there is a breach in your community rules, erase this post, instead of prosecuting on incitement. And in that extent, it makes the erosion much more immediate. And the state gets what it wants, which is to erase the post without the high threshold of, let's say, criminal liability.
Yeah, this almost sounds like co-regulation, because there's sort of, Facebook propagates the rules, and then the state is involved in monitoring those rules, and then Facebook is involved in enforcing those rules. Marco and I have done quite a lot of research on different regulatory models, not just for social media, but for media in general. And we found that there's a huge range, as you would be unsurprised to know. There's some states with like very strict state regulation, co-regulation, and then complete self-regulation by media companies. And we came to the conclusion, and I think it's there in the paper, that it is appropriate. We don't want to specify a particular type of regulation as being more in compliance with international human rights law or not. So we say it's appropriate for different media to be subject to different regulatory models. And we quote the Human Rights Committee, which says that regulatory systems should take into account the differences between print and broadcast sectors and the internet, and also noting how various media converge. We found that in some systems where the media is very well organized, where you have media councils that constantly interact with the journalists and now with social media companies, that self-regulation can work quite well. And then in other systems where you don't have such a unified media and where state regulation may be more effective. And that doesn't necessarily mean it's authoritarian. It just means that there's not enough sort of coherence in the media environment for them to self-regulate. And Germany, I think, is an example of that. So it's very interesting to hear about the Israeli example, and maybe with the media environment in Israel, that's something that is quite effective. And it sounds like, as you said, it leads to a faster reaction than going through the court system. So bottom line is, we don't favor a particular form of regulation. Instead, it's what would work best in the media environment of each state.
Thank you very much, Philippa. This has been a very insightful discussion, and I hope to read the final paper once it is done. And I'm in touch. We're actually working quite a lot on this topic here in Israel. As you probably know, the Jessup case this year was related to the topic. You may have been in the commission, actually. And in addition, I'm heading a program in a think tank in Israel, which tries to promote further regulation on the topic. We have 2 public committees which deal on the topic in Israel. So many occurrences, and I think that many people will be able to learn from this very important and thorough study. So thank you very much for taking the time to discuss it with us. And we hope to host you properly next time in Jerusalem.
That would be a pleasure. And thank you very much. And, also to say that on our side, speaking for Marco and me, we've been reading a lot of the writing, including the recent writing of Yuval and Daphna, and benefited a lot from it. So I hope that's also part of the positive interaction as well. And we will be sharing the final article in due course.
Wonderful. Thank you very much.
Take care, Philippa. Bye-bye.
Bye-bye.
See you next time.